Good morning, everybody, and welcome back to the live show. Give some shout outs here to everybody. We've got a hearing coming up with Bryan Kohberger. It starts at 11 a.m., but we're going to go over some of the new information that I haven't gone over. Some things you guys may or may not know. If I can get my tongue working this morning, will be great. So let's go. Dawn, good morning. Kate Bell, good morning. Sherry, good morning. And Nana, hope you're feeling good today, Nana. Good morning. Good morning, Fruit Fly. Dawn says, Willow, I want to let you know that the people I know with the missing daughter, she was located and returned home after 2 weeks. Woohoo! Great news, Dawn. That is awesome news. Some great news for a change. Thank you so much for sharing that. That is some great news. I just got goosebumps. There's K. Mitch. Good morning, K. Mitch. Yes, please smash that like button on the way in. Kate says, massive power outage in my town. They can't find the cause. We are with power, though, fortunately. Good to know, Kate. I know there are some pretty big storms that are coming your way and then coming to us, too. So I'm not sure if the BK is on a 30-minute delay. I haven't heard about anything of the Bryan Kohberger case being on a 30-minute delay. Annie, good morning. Dawn, good morning. And yeah, exactly. It is like great. There she is. Shy. Juror 11. If you guys haven't seen, I put out, you can find my bonfire link in the description below to my merch shop. And I've got a juror 13. So we got juror 11 here with us and we got a juror 13. Okay, so there's some things I want to go over here, you guys, before we get started this morning. Your understanding is it is? Okay, well, I've got it up here. So right now it's offline. but I do have it up, so when it does come online, I will be able to see it, and we will jump to it as soon as it does come up. Did I get your email? No, I haven't checked emails in the last couple of days. I've been really busy, but I will check it, Shy. Fruitfly says, Willow, are you getting any smoke from our wildfires? No, not where I am, no. Yes, Juror 11. Yes, so I do have for especially for the BK trial coming up. Everybody's asking me for a sweatshirt for that trial. So I do have it up. Let me bring it up quick and I'll show you really quick. If I can, let me see. My store. Okay, so let me share this. Okay, so here it is. I've got the I Object sweatshirt or shirt. You can get it in shirt, premium or classic, or just the sweatshirt. And on the back it says Juror 13. And that is thanks to Shy, always, I object. And she's Juror 11. So we got a Juror 13 here too. So that's for everybody. So there it is there. I'll show you the other ones that we do have. I've got the Welcome to the Shit Show, backed by popular demand, trial coverage. That is backed by popular demand. I have also got this one here, my guardian angel has paws. And on the back, you got the angel wings. And then I've also got, and I'm going to be adding more to this, you guys. I've also got Those We Love Don't Go Away. They Walk Beside Us Every Day, with the angel wings in the back. And with all of these, you guys, there's different colors that you can get in these. So just click on your color here, click on your size down here, and click on if you want the t-shirt, you want the hoodie, whatever, you select that here. So that is that. Yes, me, myself, and my demons. And where is that being sold, Shy? Where are you selling it? Because I will definitely buy myself a copy. Let me write it down. You know me and my memory. It's called Me, or send me a link in my email so I can get to it. I'm writing it down. Where can we find that book, Shy? Fruit fly is in Northwest Ontario. Nope, we're not getting any of that smoked fruit fly. Yes, congratulations. Thank you, Nana, for putting that up. Congratulations. And Shy is thanking everybody. Yes, I'll definitely be buying a copy. You know that. Okay, so now let's get into what's been going on here in the Bryan Kohberger case. Now, things that I have found out, we're going to go through the video. Found it on Amazon. Okay, I will check that out. Okay, let's get going on this because I don't think they are. Nana says they're on a 30-minute delay, but I don't know about that, so I want to get through this. If we don't get through it all, you guys, we can do it during a break or whatever. We can finish it off. But I was watching Ashley Banfield. Now, I've got a lot of information from her regarding, like how Kaylee was found and all that. But she did another update after. Good morning, Norma. There's Norma here with us too. She did another one, and I will link it in the description below after the video. But there's photos of the car and everything speeding away, new photos, and you can clearly see it's a Hyundai Elantra. Good morning, Jill. Good morning. Good morning. Also, his fascination with Ted Bundy, his searches of, how can I say this, P0ORN sites. He also had photos saved to his phone of girls from WSU and Idaho State University on his phone in bikinis. He also, after the crime, searched the crime and searched his name. And this is one thing that I don't think I've heard anybody talk about. After the crime happened at 1122 King Road, remember before he was seen in the area numerous, like 23 times or something late at night, almost like scoping out the place? Other than a few hours after the crime at 9:30 that morning, after that time, he never went there again. So that's very interesting. And I hope that that is brought up in the trial, because I haven't heard anybody mention that. That now I have heard it in court, them say, like, since since the incident, except for 9:30 in the morning, there was no more incidences documented in any court documents or anything about him ever being there afterwards. So there was no more times that he went to that area after November 13th. Now, Ted Bundy, I don't know a lot about the Ted Bundy stuff, but I know that he broke into a lot of females' places in the 70s, between, I think, 74 and 78, 1974 and 1978. And a lot of them were college and university students' houses. He was executed in 1989 in Florida. So let's get into this video. I'm going to start it off by Ashley Banfield talking about the pool party that he was invited to. So let's go ahead. I'm going to share this. Hang on, Chrome tab. I think it's here. Share audio. And if you guys can hear it, make sure you put a 1 in the chat so I know that you guys are hearing it, okay? So here we are here. Don't worry, I do have the court pulled up already on my other screen. I will see when they go live, and we will jump right to it. Okay, so here we go. I'm going to be only playing certain parts of this. I'm going to be playing it at 1.5 speed until we get to the pictures and the video of the car, okay? So let's go here and let's start.
Kohberger seemed awkward at the party, that he didn't seem to know anybody, and she could tell that he was trying to put himself out there, and Holly felt, charitable, obligated to talk to him. And then Kohberger put his cell phone number into her cell phone contacts and texted himself from her phone. She later texted back just her name, Holly. At this same pool party, a witness says he saw Kohberger fixated on 2 women in bikinis. One of them was married and gave her husband one of those non-verbal signals like, rescue me. We all know them.
Okay, so can you guys hear all of it? Can you guys hear it? Okay, great. Okay, so he's invited to this pool party by somebody after he just moves in. He meets up with this girl, Holly. He goes to put his number in her phone, but he texts himself. So he has her number. She didn't give him her number. He texted himself so he would have her number. Spooky, eh? So let's continue. And then he fixates on this married woman, okay? And this married woman says, hey, look, I'm married. Just listen to this.
Right? The same witness says that Kohberger didn't seem to get the message or ignored it outright, and that he brushed the husband off and sat down at the edge of the pool, even closer to the women. The day after the pool party, July 10th, NBC reports that Holly got a text from Bryan Kohberger. It said, hey, I'm pretty sure we spoke about hiking trips yesterday. I really enjoy that activity, so please let me know. Thanks. Holly told Dateline she thought it was robotic and awkward and strange and that it was just not the kind of normal language that people would use, and ultimately she just never responded.
Okay, so that's what happened. I don't know if she knew that he, like when he says, give me your phone, I'll put my number in your phone. He did that, but then he texted himself. So he had her number. I don't think she knew he did that until she got that message. Hey, we talked about hiking. And I mean, like she told him, like, I'm married. She even had the husband come over and he just ignored it, like brushed him off. Like, that is spooky. Okay, so now we're going to go to 423. Now, this is regarding the woman that he shared an office with. And she had some kind of romantic interest in him. So let's listen to this part.
When can a cop detain you? In September, a Korean woman with whom Kohberger shared an office at WSU, somebody Dateline described as one of the only friends that Bryan Kohberger had. She shared with NBC that she believed someone had broken into her apartment because her stuff was rearranged weird. A cake that she had baked was found in the microwave. Items in her bathroom were lined up in an odd way. And 2 other things were missing: a watch and a letter.
Can you imagine that? A watch and a letter. Coming home and seeing a cake you baked, not where you put it, it's in the microwave, and your makeup lined up instead of being like around your sink like us women do, it's on the toilet seat and stuff like that. Her keys go missing from a drawer in the office that she shared with Bryan Kohberger. Let's listen. And he steals a personal letter from, I believe it was an ex-boyfriend of hers.
Letter. A letter. Not a lot of value for just a old-fashioned burglar to steal a letter. But that was what was gone: a watch and a letter. Later on, this same woman told the police that before that break-in had happened, she'd lost her apartment key. She said she kept the key in a specific drawer in her office, the same office that she shared with Bryan Kohberger. A few hours after she noticed that it was missing, the key mysteriously reappeared. So feeling unsafe after the break-in, Dateline reports that she went to Kohberger's apartment seeking his help. Remember, she thinks they're friendly, close even. And now looking back on things, she wonders if he was the one who broke into her apartment in the first place and did all those very strange things.
Okay, so she goes to him for help. She ended up staying the night at his house. Can you imagine what could have happened to her? Okay, so let's jump ahead here to here. This is his searches, the dates of the searches that he was doing on his phone. Okay. And what he was searching for. This is just before the crime.
Social media, searching women at WSU, Washington State University, and the University of Idaho, too. October 5th, 3:29 a.m., more searches of women. October 9th, 2:15 a.m. He Googles explicit terms related to pornography, like forced, passed out, drugged, sleeping. October 19th, 5:37 a.m., another search. Can psychopath behave prosocially? In the Dateline episode, there were a number of new...
Okay, so I'm going to slow it down for this, you guys, to normal, because this is where they're going to show the new photos that came out and the video of his car. So what got me with these new photos that he took after the red drums, okay, you're going to see the dates on the photos. So these are after the red drums. These pictures, it's almost like he's reliving him covering himself up and stuff like that. And it's eerily close to a photo that is on a book of Ted Bundy, where his face is dark and he's just got this black hood on, like hoodie. And it's almost like Bryan's trying to recreate that photo of Ted Bundy. So let's watch.
blurry selfies of Bryan Kohberger on his own phone. Keith Morrison said the photos were resized for quality, but otherwise unchanged.
See that? November 27th. Let's back up just a minute.
Keith Morrison said the photos
See, there was a series of 3 photos. Like, this is eerie.
were resized.
Like, even this. Like, that almost doesn't even look like him. And people are saying that he has his hair cut like Ted Bundy, too. And this is November 27th, this one. And look at WSU on his sweatshirt.
For quality, but
And there's pictures of a girl that he got up on her balcony, and it's a Phi Chi or something like that. One of the sororities that Ted Bundy, a couple of the girls were from a specific Pi something. And there's a picture of that regarding Ted Bundy too. So it's weird.
otherwise unchanged. Many were of Bryan in black hoodies, sometimes wearing.
See this? Like, it's almost like he's trying to recreate the photos of Ted Bundy. Look at December 21st.
Wearing 2 layers of black clothing.
Look at this.
Different poses, different outfits. He also.
Okay. What do you guys think? Yeah, he was a HON addict that apparently he kicked it. Did he kick that habit and like to lose the weight so he could be the same body size too of Ted Bundy? I wonder if Ted Bundy boxed, if he was a boxer. Because Bryan Kohberger took that up too to get in shape, right? So I wonder. It's eerie. Let's continue.
Also had screenshots of various Instagram profiles saved as pictures to his phone. The screenshots were photos of young women, blondes, brunettes from both WSU and University of Idaho.
He had them saved as screen savers. Some of them. He had a bunch of them from WSU and the state of Idaho. And some of these girls are friends of Kaylee, Maddie, and Xana, right? He used some of these photos as a screensaver. I think there's one here that they show that's actually Xana and somebody. Hang on.
According to Dateline,
Like, is this Kaylee and Xana or Kaylee and somebody?
some of the people whose social media was saved onto Kohberger's phone.
Like, is this one of the girls in here?
Were either close friends.
See, this one to me looks like Xana. This one right here. You know how she has her hair pulled back all the time?
Or social media followers of Maddie Mogan, Kaylee Gonzalez, and Xana Kernodle.
Remember what I said, you guys, when I did that very first video in December? Before we even knew who Bryan Kohberger was? Do you remember that video I did? You guys can find it in my videos under Arrest Coming. If you type in Arrest Coming, Above and Beyond Ancestor Readings, you'll get that video. I do believe it's pinned on my page. But before we even knew who Bryan Kohberger was, I described him to a T. I described that he would be some kind of teaching assistant or gave lectures or something, that he took something from one of the victims, that he parked in the back and came down here and went through the sliding glass door. I also said that he went upstairs first and then got Xana. And I said, Xana probably, went to put something in the kitchen or something. That's how he got her. That all came out long before we even knew who Bryan Kohberger was. It's eerie. To me, it's eerie. Okay, so I want to jump to here. 8:35. Okay, let's start here. Okay, so here is the car. This is a new video of the car.
Are making multiple passes in front of the house at 1122 King Road. all captured.
See that? You can see it's a white car here. Look at, I want you guys to pay attention to how slow the car is going each time it leaves until the last time.
Captured on camera at these times.
See how slow he's going?
3:30 a.m., 3:33
See how slow he's going?
a.m., 3:38
There he is
a.m.,
leaving. Here he is coming
3:40
again.
a.m.,
See how slow?
3:56
See how slow he's going?
a.m., 3:58
Look at how slow
a.m.
he's going. Look at that.
And then at 4:20 a.m., the white car speeds
Okay, now watch how fast that car takes off. It's the same car. Watch how fast it goes after the red drums.
away.
Look at this.
In the footage, you can hear
Zoom,
what seems to
zoom.
be the white
Like
car's
he
engine
doesn't even stop here. You see how fast that went compared to the other times?
revving up.
I'll play it through now by all together without interruption. And you guys watch how slow he goes coming in, the multiple times that he comes in, and then the last time after the red drums, how fast he leaves. Watch.
A white car making multiple passes in front of the house at 1122 King Road, all captured on camera at these times. 3:30 a.m., 3:33 a.m., 3:38 a.m.
See how slow that is?
3:40 a.m., 3:56 a.m., 3:58 a.m. And then at 4:20 a.m., the white car speeds away.
Look at
In
that.
the footage, you can hear what seems to be the white car's engine revving up. Here's what else is new.
Right? Come on, you guys. What do you guys think? You see how slow it was going? Oh, my chat's stuck, or nobody's chatting. Do you see how slow it went, those first 3-4 passes? We'll say 6 because he comes in, he goes out. He comes in, he goes out. He comes in, and then and goes out maybe another time, comes in, and then that final time, like he don't even stop at that corner. He's like zooming. Yeah, like a bat out of hell. Okay, so let's go to 9. Well, I guess we can just let it play. This is new too. So after the red drums, okay, so he gets home, remember on the mapping we did and everything, he gets back to Pullman apparently 5:35 in the morning, almost an hour after he gets home. This is what he does.
At 6:17 a.m., not even 2 full hours after the white car was seen on surveillance, leaving 1122 King Road, Dateline reports that Bryan Kohberger makes a 36-minute phone call to a number on his father's family plan.
Okay, so he at 6:17 a.m. he makes a 34 minute. So that would bring it to about, let's see, 34 to 7:41 a.m., right? But then he makes a 54-minute call. So let's go 7:41 to, and add 54 minutes. So that would bring it to almost 7:41, 8, almost 9 o'clock. And then don't forget, at 9:30 in the morning, he went back to King Road and seen nothing going on. Then at 10:30 is that picture of him after showering with the thumbs up. So to me, it's like 9:30 in the morning, he goes back there. He was Googling, didn't see nothing. So he went back there. He didn't see no cops, no nothing at 9:30 in the morning. Hello, Kat. Hello, Carol. So he goes back to his apartment in Washington and probably has the shower and takes that thumbs up picture like, holy shit, no, it's been hours now and nobody knows yet. Thumbs up. I'm going to get away with this. That's my thoughts on that. But let's listen.
And apparently, every family member had a phone registered to Bryan Kohberger's dad. It was the first of three calls to numbers registered to his dad that morning. And the longest call, that lasted 54 minutes. And then, as we know, at 10:31 a.m., he takes that now infamous cell.
Okay, so she forgets to mention, so that brings him right around the 9. There's 3 calls, so we don't know how many minutes the other call was, but the 2 calls that we do know the length, one was 38 minutes, one was 54 minutes, so that brings us to almost 9 o'clock. So after these phone calls, he jumps in his car and he goes back to the area of 1122 King Road. He sees nobody around, no cops, no nothing. He goes back home, and within, okay, so say it takes him 10, 15 minutes to get back home. Within 45 minutes, he's showered and taken that picture with the infamous picture now with the thumbs up. This is like disgusting, right?
Selfie in what looks like a bathroom, smiling, seemingly very pleased and seemingly freshly showered. Keith Morrison described that once police were called and arrived at 1122 King Road that morning, they found Xana Kernodle in a massive pool of blood. They found Ethan Chapin, according to NBC, dead in Xana's bed.
Okay, so that was another thing that had come out in, my reads and that. I'd said Xana either, went and because she heard something, or she went to the kitchen to put the empty bag from the food she ordered. She did something, and I believe that Bryan Kohberger had been coming down the stairs and seen her, and she tried to get back to her bedroom, and he caught up with her. And I said, I believe that Ethan was in the bed, and he got Ethan in the bed. And that's where we see the red stuff on the outside of the wall outside, right? And everybody's saying, no, that's not how it happened. That's not, okay, well, whatever. Let's see when things come out and look at now, right? And then they're going to describe a little bit about Kaylee and Maddie that we already know being found upstairs. So let's continue this a little bit, and then I got to cut it off because there's music that's played. I'll discuss that. I'm going to block the audio for it, but the words do come up on screen. So I'll be able to show you what he listened to afterwards.
And then there's what Dateline revealed about the crime scene itself. They say Xana may have heard something upstairs on the 3rd floor and maybe even gone to check on Kaylee and Maddie up.
See, I don't know if she heard something from upstairs or she was just going to the kitchen to put her bag from her food in the kitchen, right? Or maybe grab some salt and pepper from the kitchen for her food or something. I don't know. But I know that what I was seeing was her going towards the kitchen and Bryan Kohberger seeing her, or whoever the perpetrator was. We didn't know his name at the time. But I said whoever that did this was probably coming down the stairs and seen her, and she tried to run back to her bedroom but didn't make it. He got her.
There. According to NBC sources, Xana was likely chased back downstairs to the 2nd floor, possibly the moment that Bryan Kohberger, if he's the killer, dropped or left behind that knife sheath. The fight that followed in Xana's room, according to Dateline, was brutal. So brutal that investigators found a blood-stained chair.
Listen to this, you guys. This is something we didn't know. Listen to this. I'm going to back it up just a couple seconds so you guys can hear it all. Listen to this. Remember everybody saying, oh, one person couldn't do that. They'd be out of breath and everything and blah, blah, blah. Watch this.
Found a blood-stained chair, suggesting that the killer either sat down or brushed against it during the attack. And then, as for Ethan, Dateline again with some astounding information. They report that one of Ethan's wounds pierced an artery and that his legs were, quote, carved. Their words, carved. I have to just jump in here for a moment because
Okay. So then they go on to describe Kaylee and Maddie, that they were found together. That's basically what she says about it. But let's go to here. I want to go back to the one photo here. There's an aerial photo. Where is it? Is this it? Give me a second. I'm trying to get to the aerial footage. Okay. Whoops. Where'd it go? Right here. Come on. I can't play this part, you guys, because there's music. This is what I'm trying to get to. Right here. Okay. So right here is where Xana's bedroom was. Right here. And the camera that picked up the noise and the thud is right here. This is also the camera that picks up his car. I'm here. Juror 13 is here. We're all Juror 13. So this is where the camera was that picked up the noise, and here was Xana's bedroom. So it's really not that far. Okay? So listen.
also aired some chilling audio captured at 4:17 a.m. A faint whimper followed by a loud thud. Presumably, this audio was captured by a neighbor's ring cam or door cam or surveillance camera. And we know.
Okay? So the house is now gone in this photo, but here is the front of the property. This is the driveway. This was the sidewalk in front of the house, like the little bit of cement that was there, where the first floor bedroom was. Xana's bedroom would have been right here. Look at how close that is to where Xana's bedroom would have been right here. Good morning, Tracy. Right? Okay, so then I want to jump to, look at this, and this, I can't play this because I got music playing here. I want to get to here, but I've got to turn off the sound, okay, for this video because it's Britney Spears. Now, apparently, Bryan Kohberger, I believe, okay, wait, let me put the sound back on for a minute and then I will, hang on.
December 30th, police raided the Kohberger home. And then, new information, again from NBC, at 11:53 p.m. on December 29th.
Okay, so 11:30, whatever she just said, on December 28th, that's when he got arrested. That's like a couple hours before they busted through and arrested him. He was listening to a Britney Spears song in slow, I guess there's a slow version of it. And this is what it said. You're not going to be able to hear the music, but you'll be able to see the words come up on screen. I don't want a copyright strike, so I'm not going to play it. But you'll see the words to the song on screen. Watch this. Hang on. It's coming. Sorry, guys. So this is there's two sentences that are here. That's part of the song, and he's playing it in a slowed down version. He is a villain by the devil's law. He is a, here, just for fun, 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 fun. He's got no conscience. He's got none, 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 none. That's what he was listening to just before he got arrested. This was about an hour and a half before he got arrested. This is when he was walking around in shorts with a hoodie, with a black hoodie with a hood on, and wearing gloves separating his trash. That's what he was listening to. So that is it for that, you guys. See, I was hoping it brought us right to the time. Let me just see. It's still offline, so let me go over here and see. Okay, it's still not up yet. So maybe Nana was right. Okay, hang on a sec, you guys. Oh, I hate this guy. They should have never knocked the house down. No, I don't believe they should have either. Um, yes, I believe it's a public hearing. And so far it is saying it is not. So maybe Nana is right. Hang on, let me just get the volume on here. So I will hear it. Give me a second. I'm going to check over here. Okay. 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 Hang on a sec. Yeah, see, right now it's still offline. But I've got the volume up, so when it does come online, they're always a little bit late too. So, like, people have got to come from Moscow to Ada County. It's like, from what I hear, it's a quite a long drive, but they're never on time anyway. So I will jump to it. Hang on, let me just see. Um, Let me go to here and I'll let you know what's going on. Okay, so it is being televised because I've got the rules for it here. We can go over that in a second. Hang on. And it is scheduled to start at 11. Hang Let me just hear this. Yeah, it is supposed to be starting at 11, you guys. Okay, so it is supposed to be starting at 11. I do have it up. Um, well, let me go here because there's a new filing. Oh my gosh, there's tons of new filings overnight. Okay, we can go over these afterwards if we have time, but let me bring this up. Marie Barks, remember 42 months? Okay, so let me share this with you while we're waiting. Amended order governing courtroom conduct, and Brian Enton is in the courtroom, so that's how I know that it is. They're all waiting for it to start. And he did say that it is going to be televised. So we're just waiting for the court stream to get up. We know that they're always late. I have the court stream up and I will hear it in the background when it comes up. Okay, so to provide for the orderly disposition of this case, this is 4 pages. This order shall govern the conduct of the public and the media in Ada County Courthouse for the entirety of this case, including the jury trial, and supersedes any prior courtroom conduct orders in this case. The court is mindful of the need to balance the constitutional rights of the defendant to the public's interest in the right to information in conjunction with certain constitutional and statutory rights. Okay, so we're just going to go over what the judge has ordered. Seating and attendance in Ada County courtroom. Seating for victims' families of defendant, counsel, other court personnel. Certain seating may be reserved by the court for designated individuals, including but not limited to authorized court personnel, security, the defendant's family, statutory victims, and others specified by the presiding judge. Public seating, subject to the need for reserved seating referenced in 1A. Seating for the public, including media, will be permitted in the courtroom as space permits, pursuant to a reservation protocol established and administered by the trial court administration. No person may reserve seats except as indicated in 1A above. Standing attendance when open seating is unavailable will not be allowed. So if you can't sit, you can't be there. Entry and exit. All spectators, including members of the media and the public, shall be seated before the court is in session and during any portion of the trial. No entry or re-entry to the courtroom shall be permitted while court is in session. Other restrictions, security screening. All persons entering the courtroom may be subject to additional security screening. Handbags, backpacks, and other carry-ins are subject to inspection. Cell phones and other electronic devices in the courtroom. Thank you, Kate Bell. Cell phones, tablets, laptops, or any other electronic devices shall be turned off or be in silent mode and shall not make any sound to create any distractions. Devices shall not be used to record, photograph, or transmit any sounds, images, or video from the courtrooms used during the proceedings. Phones or other handheld devices capable of recording should not be used, held out of pocket purses while the court is in session. Laptops or tablets used for note taking must have any recording capabilities disabled and are subject to inspection. Interviews and reporting. No media interviews or reporting shall be conducted inside the courtroom except for written reporting such as live tweeting. The public, including media, is also subject to the order. Thank you, Kate. Thank you, thank you, thank you. Destructive behavior. Any activity or behavior which is destructive may result in removal from the courtroom. No person shall demonstratively react verbally or non-verbally to evidence or arguments, or otherwise attempt to convey opinions related to the case while the court is in session or jurors are present and can potentially see or hear the same. No person shall attending court may wear or otherwise display anything or make verbal statements verbally or non-verbally that in any way could be construed as conveying any message related to this case. Streaming court proceedings. Hearings that are open to the public will be streamed. Okay, so that's his orders. That is his orders. Oh my gosh, there is tons of new documents that have been filed, and they are not going to be heard today. All of these new ones. Um, wow. There's a state's motion to reclaim exhibits. There's state's motion to seal exhibit S1 to state's motion to reclaim. Amended order governing courtroom conduct. Second motion to seal defendant's proposed jury instructions. Second motion to seal. Okay. Order permitting state to reclaim exhibits. Order sealing exhibit S1 to state's motion to reclaim. And order sealing state's amended exhibit list. Wow. So we're not going to get much from them anyway, but okay, let's go back over here. Hang on a sec, you guys. So just 38 minutes ago, they were still waiting to get into court. So it looks like he's in the courtroom. So it should be starting, you guys, soon. Thank you again, Kate Bell. I'm waiting for it to stop so I can mute and listen on my speakers. I guess I can now. I can take these out. Hang on a sec, you guys. My earbuds died on me, so. And if you listen really carefully, you can hear my cardinals out back in my tree. And I keep refreshing the stream where court is supposed to be shown, but it is still not on yet. And like I said, as soon as it does come on, I will put it up. Hang on a sec, you guys. Juror 11 Shy says, I will wear my I Object hoodie. Thank you. There you go. Go ahead, get over there and grab yourself an I Object hoodie. Okay, give me a sec, you guys. It's like a ding dong, Avon calling. Okay, so like I said, we are waiting. Hang on a sec, you guys. Let me put this here. Oh, I can't do that. Okay. So I guess we're going to have to wait for it to start before I can bring up the big screen of it. So I just got word that the hearing is running late because there was a previous case in the courtroom that they were supposed to be in, and that just is finishing up. So everybody was pushed back out into the hallway. They are wrapping up the case that is so the hearing is running late. It was supposed to start, from what I'm seeing from all the tweets coming out from there, is that it's running late because of another court case that has just finished up. Okay, there we go. Okay, you guys, I'm going to get it up on screen. There we go. There we go. So, like I said, there was a case that had ran a little bit late. So, which pushed Bryan Kohberger's case to be a little bit late, right? Stormed here in Colorado last night. Oh no. I hope it wasn't too bad. You think the storms are coming through tonight? Kate says we got 83. It's 22 degrees here right now, Celsius. I don't know what that is in Fahrenheit. That's probably going to be about 73, 74. It's the warmest that we've had so far since winter. So, a windy rainstorm. Well, I'm hoping all your snow is done out there in Colorado too. Thank you, Juror 11. Shai says it is 22 Celsius is 71.6 Fahrenheit. Carol says it's 54 Fahrenheit where she is. You take 22 times 1.8 is 32. What? Oh, plus 32. Okay. Like, I keep my house at between either around 18 degrees Celsius, which is about 68. Kate says it's supposed to be 90 today. Warmest here since winter. Well, yeah. Yes. Nana, there was a court case that was in court that ran late, and it's in the courtroom that they're going to be using. So that is why it has run late. I checked out some of the reporters that are there, and that's what they are saying, that there was another court case that ran late in the courtroom that they are going to be using for Bryan Kohberger. So that's why it's late. So there is no 30-minute delay in the Bryan Kohberger case. It's late today because of the other case. Trying to preserve yourself, Willow? No, I can't. I've got asthma and COPD, so I can't sleep in the heat. My air conditioner is already in, and I keep it at about 67, 68 in my room. So if it gets above that in my room, my air conditioner comes on. Marie is out in California. She says it was 100 degrees last week, and now it's in the 70s. Wow. Come on, court, let's get going. I can't. And you guys seen like how many things have been filed since the last hearing? there's like 30 things that have been filed, and it's like, holy crap. And there was more filed last night that I just seen, but it's all sealed. We can look at it after the hearing if there's time, um, to see if we can get any little tidbits about what it is. We'll check that out as soon as the hearing is done, or during a break we will check it out. Yeah, I agree. Shai says she's in the middle of Nebraska. I can't wait to go and check that book. I am going to buy it. And I will show you a picture of it when I buy it. I'll show it on live stream, and I will promote the hell out of that for you. Marie says, I call it earthquake weather. Oh no. That's all you guys need after what you guys went through last summer, Marie. Right? Yes, I did hear about the earthquake in Tennessee. And Nana says, you're right, Marie. So it's interesting. So I know there's other things that have come out that we haven't covered yet. I didn't think we were going to have time. If I would have known that this was going to happen, I would have just had this up and in the background, and we could have just waited. But anyway, lots more information about. I think I brought it up in a earlier live how Kaylee was found and the disgusting things that were done to her body. Um, it's just horrible. I wrote a book, right, Willow? You wrote a book. Oh my gosh, Marie, you want me to remember? Remind me, Marie. Oh my gosh. My memory is so bad, you guys. My really extended long term, ask me about something from 1977, I'll tell you word by word what happened. Ask me something in the last year and a half, 2 years, even yesterday, forget it. Like, it's like a deer in headlights, huh? What? Oh, thank you, Shy. I appreciate you too, and I will be buying that book. And like I said, I will show it on live when I get it. Let me just go while we're waiting. The cat says mine too. Yeah, same here, Nana. We don't get tornadoes. We got a microburst that came through. We've had a few of them come through. A microburst that came through after that big, huge hurricane that went through in the States a couple weeks ago, and it took off a huge limb of my tree. So, okay, give me 2 seconds. I just want to go to Amazon and see if I can find this book. Book called Me, Myself, and My Demons. Well, spell it right, Willow. Uh, Demon called Irresistible Demon. Demon's Dream. You make me want to fight me. Duet with a demon. Hang on, I gotta find it. Oh no. Uh, I don't have it on my Amazon. Why don't I have it on my Amazon? I am certain. No, there's only, like, there's quite a few with demons in the name, but I can't find it. Okay, hang on. Hang on. I gotta write that down. Hang on. BOF4G3HFJX. Okay, just me, myself, and my demons. Me, myself, and my demons. That's what I put. Okay, hang on. Let me put that in what you just gave me. BOF4G3HFJX. Search. Oh my gosh. I got, nope. Oh, wait. Nope. It doesn't come up. Well, I'm Canadian too, so, nope, it doesn't come up. The only thing that comes up is 7 Artisan's True Color VND Adjustable Neutral Destiny Filter 2.5 levels. I don't even know what that's for. It looks like it's for a camera. BOF 4G 3 HF JX. Yeah, it doesn't come up. It doesn't come up. Me, myself, and my demons. That's what I... Me, myself, and my demons. Demons. Oh, yes, I do got it. Oh, it's only Kindle edition. I can't buy it in paperback because I don't have a Kindle. I don't have Kindle. Okay, hang on. Let me see. Hardcover, paperback. Has it got your artwork on the front of a girl taking off a mask? Shy? Court's going to be beginning soon, you guys. It's in all 3 options. Yes. But tell me if this is it. If it's a picture. I don't want to say your name. SE is your initials. And it just says just me, myself, and my demons with it looks like on lined paper a picture of a girl with a blue eye and a mask coming off. Is that it? Okay, I'm ordering it right now. Free delivery Saturday, May 17th. So guess what? Add to cart. Cart. Proceed to checkout. Place your order. I just ordered it. And it will be here on Saturday. Let me just make sure of that. Delivery Saturday, May 17th. Okay. So I ordered it. It's going to be here May 17th. So guess what that means? Okay, why is this showing again? Hang on. That means I'll be able to show it for my live on Sunday, because I do live reads for you guys Sundays at 1 p.m. Eastern. So guess what I can show you coming up on Sunday, because I get it Saturday. I will be able to show it in my live on Sunday. If I'm awake, because I'll probably stay up all night reading it. Marie says, my book is called Knowing When It's Safe to Run. Marie, is yours on Amazon too? Marie, is your book on Amazon too? Or did you publish it? Oh, well, where's my copy? Didn't send your sister a copy? What is up with that? I don't know anything about publishing. Maybe Shai can answer that. Shai, can you self-publish? And Marie has got to send me a copy of that book. Oh, come on. Okay, let me see if... let me go over here and see if I can't see what's going on.
State
Here we are.
Kohberger, the
Okay, here we go. You
defendant
guys put one in
and
the chat
counsel
if you can
for
hear.
both sides previously identified are present. We are in the public session now. I have
Oh, so part of it was not open to the public.
my own agenda for what to cover today in the pretrial motion, and so I'm not sure what you have. I didn't receive any specific motions to cover today, other than, I think, the ones previously submitted by defense related to questioning of the jury. As I indicated, I don't intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages, and as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion. So starting with some general issues, I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want, and that certainly is a large part of it, because if you know what I expect, I think it makes your job easier. And so I, particularly where I can't recall whether Ms. Massoth has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from the sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now. I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial. For a couple reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be an quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties' stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given. I think I'd asked you also to work on an instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, you know, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So, with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Hurwitz facilitated the defense viewing it yesterday.
Okay.
It is available for the court's inspection well if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. It is an inappropriate characterization. If I'm responsible for it, I assume responsibility, but that's simply not an appropriate way for it to be described given what occurred there and the victims.
I think a better term is simply a model,
Yes, sir.
Rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
Your Honor, we did. We were able to bring 2 experts in per our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the third floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence vault of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in
I
as a
see.
demonstrative aid, I am curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom when it's not being used, but nearby in the event that a witness does wish to use it.
Thank you, sir.
The other thing that I would point out, as it sounds like you've been, at least to some degree, working together, and I appreciate that. As you come to stipulations on agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is in the middle of, for example, trial, well, Honor, the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible. I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions that I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're, who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire, so that they don't just get a list of 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania. These are witnesses that work for the FBI, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names, to see if they know anybody. And I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense had, we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient, because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. And I want some additional information. What I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Your Honor, on June 18th, Ms. Massoth has a conflict in the morning, but we could do an afternoon hearing on that day.
Can we do the 20th? The 19th is a holiday, and the court is closed. I'm just not sure whether it can be done in a half a day or in the afternoon or not, depending upon where we're at. That's my concern.
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons, if we could avoid that date. If we can't, then I guess we can't.
Well, let's, can we start by like noon on the 18th?
12:30 or 1, I'm in federal court.
All right. Let's do 12:30. Are you handling those issues?
Alternate perpetrator, I'm, yes, very involved.
Let's do 12:30 on the 18th. All right, next I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So I won't ask you if you have questions now because I suspect it will fit into, if you do, a more specific category and we can address it at that point. But if you have a question or concern about anything we've talked about thus far, now's your chance.
I don't believe so, Your Honor.
No, Your Honor, thank you.
All right, juror questionnaires.
Give me a minute, you guys. I don't know what's happening here. Hang on. Okay, I got it back.
Questionnaires, then watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to council on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for one or not proposition.
Thank you, Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, very well. Does that accord, Ms. Taylor?
It is, Your Honor.
All right, very well. So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms. The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
No, thank you.
We'll waive our presence for that, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires. As I'm sure you're aware, pursuant to Criminal Rule 23, those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes, but copies you receive will be returned. The defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us just with the magnitude of the task. We'd like to have the assistance of our paralegals in organizing and reviewing.
Sure.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality because it is part of what I'm giving the jurors on the instructions, is letting them know that there's very limited number of eyes that will review this, and that the public never will, so. The plan will be to try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer, right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat. Any questions about the juror questionnaire process?
Sir.
So the next topic I have is voir dire, more specifically. Traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to. But otherwise, the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to, but the idea is after that more group discussion, the individual voir dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question?
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? and just to make sure I understand, then whoever's left from there, we pull in and then we talk about case-specific information, the media items?
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and we kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual, so you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views, it makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So let's, and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues, or they may, simply give a view of capital punishment and that one that it's clear that they're not qualified, either one side of the coin or the other. But if you want to deal more, if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how the questioning will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendants' family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit, because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is. And I want to protect the juror's privacy as much as possible in that regard. And so this does allow for a public access is the right, but also allows the court to tightly control that process. And then the individual voir dire will be counsel and the defendant only. And there'll be no stream.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. It'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them, will that be on them, or does this court use paddles so that their numbers can be held up when we want
They'll
to
have a
observe?
laminated paper, like 8x10 paper that has cardstock laminated that has the number on it.
Thank you.
And it'll be the scramble number, not their original reporting number. My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get to at least through 3 panel a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, and let's say that number's 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then
That have
exercise.
been passed for
peremptories.
cause, correct. So once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to rule, gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between. Any questions about that process? Okay. So, and then when we're exercising the challenges, what I do is I give you a time limit geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything. If you both pass on a round, or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that rule as you go in. After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, the lottery to be an alternate. But that group of jurors, and so the 20, will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial. to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if the juror, if you happen to see a juror somewhere else in the courthouse or at the grocery store or at the coffee shop, you're not to even engage in pleasantries. Turn tail and run the other way as fast as you can. If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to. I issued yesterday an order in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, if you intend to have staff stay at a hotel. Let us know where that's going to be. You will each be assigned a conference room outside the courtroom, and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your papers and files if you'd like, or other materials, and use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process or the jurors?
No, sir.
No questions, thank you.
So the trial itself, the plan is to go from Monday through Friday with the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day is so that they can do the errands of life that they need to do. But if we are hosting them, so to speak, we don't have to worry about that, and I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go at 8:15 each morning. From 8:15 to 8:45, if there are issues to discuss, that's when we will do them before trial starts. As I encouraged you when I first started this morning about this, this would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up the next day or in the near future. At this time, I do not intend to have trial on October 2nd and 3rd. Because of a previous commitment that I have. I had talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are holidays for which there would be no court, with the exception that if we are sequestered, we may have trial, and we'll address that as we go. Because I can't send jurors home for the holiday, and so we might as well use the time. Any questions about that trial schedule? Okay. All right, in terms of special needs that you may have for trial, I'm assuming there's no need for us to have interpreters for any witnesses.
No, sir.
And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes. Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology? In terms of what we provide, it will be a overhead, what we call the Elmo device, which is the device where you set a piece of paper down and it projects onto the screen. And then we have a HDMI link for your computer to present whatever you want to from your computer. That's it. That's our technology. So Anything beyond that, you'll have to bring. All right, let's talk about seating in the courtroom, counsel table, and the trial broadcast. Each side, I think when we toured the courtroom, each side will have two counsel table put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members. The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers. Understanding the space that you have in the well. How many seats do you need? How many seats are you requesting and how many seats do you need are two perhaps different issues, but in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you? For the state, likewise, 3 seats, 4 seats?
You should be able to make that work, Judge.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating. What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, is for those that have reserved seating, in particular the victims, and I should point out I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not, given the way they've been treated in the media, but if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, I would like to know, for example, we're not going to use 3 of the seats on Tuesday. So that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and which days you won't. That goes for both the victim's family and the defendant's family. Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are, or who are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later to go over sort of what that process looks like so that gets, so the media is aware and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be run on the court's, where, if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom-ins and zoom-outs and things of that nature. It'll be the static views.
Before the court goes further, when we're talking about the reserved seating for families in the courtroom, if we have some other members of Mr. Kohberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating's going to be very limited, right? And so I don't want to extend that beyond the immediate family as a general rule, but if there's a specific day or two where there are going to be a couple other folks in town, talk to the trial court administrator, and she'll see what she can do.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, it's somebody who will just assist them, as the media might try to talk to them
Sure.
a lot.
All right, I don't have a problem with that. I'm assuming the victim witness coordinator will want to be there as well, so.
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrios' office to let her know.
Are you talking about one per family?
Hopefully not like that, but we're
Thank
going to need to split at least, we're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are at a premium, but.
Yes, understood. Your Honor, may I also ask the court in regard to the live stream from the witness stand? I believe that we mentioned this, at least in passing, in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that a public live stream where their images could be captured and played games with in the media world. Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be undesirable. We will advise the court. We've asked the agencies to identify anybody in that capacity and to specify the basis, which we'll bring to the court. I just wanted to give Your Honor a heads up.
Your Honor, this case is very high profile, and we've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. I did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face. while they testify, and we may approach the court with a stipulation for certain numbers of them.
Well, my intent would be with respect to victims, and I've already indicated I think the two roommates are victims. There is a compelling interest to protect them. And so just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I gotta see where the parties land on that. If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else, you're going to have to really convince me because of the public's right. And their hesitancy can be overborne with a subpoena. And that's what subpoenas are for. So I'm probably disinclined to do that in general for other witnesses. As you can see, I'm even hesitating with people that may have a line of work that is undercover if they weren't undercover in this case. So other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Your Honor, I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group. I mean, it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time might be different. And I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
It's going to have to be a very compelling reason to do it. So aside from victims, while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. And if I start not broadcasting the testimony, the full testimony of people who would otherwise prefer not to, that's going to fill up, it's going to be a large number quickly. And the best way that we have to ensure that the public is accepting of whatever verdict that may be reached in this case is for the public to have the ability to see the evidence. So I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
All right, any questions about either the seating or broadcasting besides what we've talked about?
No, sir.
All right, let's move to then opening statements. Let me start with what you've probably figured out by now. I am not tolerant of argument during opening statement. So if somebody is arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is, by about the time that we're meeting again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time. and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, in about an hour, you're going to hear me say, counsel, you've got 5 minutes left. Use of exhibits or potential exhibits during opening statement. Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, other than spite, there's no good reason to not agree to it because the shoe will be on the other foot, so to speak, down the road. So courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, 48 hours in advance, so that I can then look at it and make a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained. Let me reiterate again, please do not argue during opening statements or in voir dire, I should mention as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well. If you are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening, rather than turning them on and off again. So I suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off. Any questions about openings? All right. Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and I'll be back, all right?
All rise.
All right, we get a 10-minute break. Don't mind me, I'm trying to open a Halls here and it's stuck. The judge is really setting down the law here, you guys. Like, he is being precise on what he will and will not allow. And it's like, don't cross him. Like, this is not Judge John Judge. That is for sure. Rose says, loving this judge, no time. Whoops. No time for playing around on his watch. Nope. For sure. He's running a tight ship, you guys. So I'm not sure now if we're going to be able to see the hearing on June. June 18th. Now, one of the defense lawyers had a problem with the morning. Apparently, that lawyer is going to be in federal court. So it's not scheduled to start until 12:30 Idaho time, which is 2:30 Eastern. But I'm not sure if we're going to be able to live stream that one. And I like how, when the prosecution got up and said, look at, so we know Bethany and Dylan are going to be testifying. And yes, they don't want to be on camera. I get it. Like, they've gone through the ringer, right? So Anne took that opportunity to say, well, you know what? We may have some people too that don't want to be on camera. I can't see the judge not. Also, when it comes to the police officers that are undercover, I think that's going to be an easy convince for the judge to either have them wear, this is going to sound bad, a balaclava to cover everything but their eyes, or to somehow blur them out, or just not have them on camera at all, just have audio. I get it, because if they're undercover, they're still undercover. If they're still working undercover, their identities need to be protected, because they may insert themselves into other cases to try and get evidence. You know what I mean? As, an undercover may pretend to be somebody who's buying illegal stuff. We'll put it that way, that starts with a D. And he goes in and buys illegal stuff from people who are selling illegal stuff to try and get evidence against them, right? So they don't want their cover blown. So I don't think it's going to be hard to convince the judge to keep them off camera. Yeah. She knows that it's this, like, especially with what has come out now. And like I said, you guys, when we would go over court documents and stuff like that and updates and whatever, throughout the last 2 years on this case, you'd have all the pro burgers coming in and freaking out and, oh, you're claiming he's guilty already and they don't have anything. And it's like, if you think what we see, if you think that's all they have, you need to get out of watching true crime. You know what I mean? So it's like, they've got tons more. We just don't know about it, especially with the gag order and non-dissemination order being thrown on this case as early as it was. We don't know everything. The only thing they have to put in that probable cause is enough to get a warrant, to get his arrest, right? So now I'd like to see some of those pro burgers in here trying to say now there's not enough. Anne wouldn't be fighting so hard and using so many different things to try and get this death penalty off the table. She knows he's cooked, right? She knows it. Like, first it was, this visual snow. Then it was some kind of something else he had. Then it was the ADS. And then it was this. Then it was that. She's tried everything. And what we haven't been able to see lately that's happened is the prosecution had a motion that the judge ruled on to be able to examine Bryan Kohberger. Like, so to have a psychiatrist or something along them lines examine him to see the validity of all these things that Anne is claiming he has. So, I mean, in your face, pro burgers, like, we all knew You guys are all smart here. You guys knew. There's more than what's just in that probable cause. So the judge made a couple of really off the wall comments. The one I remember is about, oh my gosh, I don't know if I can go back. I don't know how far I can go back here. I forget the comments now. See, I told you my memory's not good. I think it was before this. Okay, who remembers the comments the judge made that I commented on? I'm trying to find them, but I don't think I can go back that far. Yeah, I don't think I can go back that far. I'm trying. Oh, here it is. One of it is the judge said, let's cut through the chap and get to the meat. It's like, ooh, what a comment to make when Bryan Kohberger allegedly used a sharp object to cut through the chop and get to the meat. You know what I mean? Like, it was like, oh my gosh. And then there was another one. Let me see if I can find it. Let me try and find the other one. He made two comments anyway that I commented on. Another one about something, and then I said, oh my gosh, that was a bad comment. Because if found guilty, he's facing the firing squad. I forget what the comment was he made. Anyway, there was a comment he made something about shooting something or whatever, and I said, oh, that's a bad comment to make because, and something, yeah, about the firing squad. What did Carol say up here? I got through the, yeah, he didn't mention the firing squad, but the comment was something about shooting ourselves or in the foot or something like that, and it's like, oh. I'm trying. Shy. You want me to go sit in the corner? I'm trying. I agree, Shy. Rose. I'm scrolling back up in chat to see what I missed. Pro burgers. Okay, I think I've caught up. I know. I misspeak a lot of the times. I almost laughing. I see. Still YLMO. Just say. So now I'm anxious to get your book, Shy. I need another Halls. Not that it's going to help. It just keeps my throat not dry. The pollen here is crazy. My next door neighbor's son came home from school. He's allergic to it, and they thought that they were going to have to take him to the hospital. I'm not quite that bad with it, but the pollen here has been crazy. So, okay, let me look at my paper here. My squirrels are scratching at my back door because I haven't given them their nuts this morning. Oh, this year has been horrible, Rose. Horrible. Rose says allergies are no joke this year. Yeah, they are horrible. Willow says, can you read to us every day, Willow? Oh my God, I would have no voice. Can you imagine? I'm trying to look at what we missed before court started. The Ted Bundy thing is really getting me going. Marie Squirrel. We did go over in a previous video that paper that he wrote, well, the mini novel that he wrote for one of his exams. I think it was his year end. That he explains how he would go about getting away with something. That's not the title of it, but it basically shows what you need to do, like to cover your tracks and everything else. If you read through that document, go back to I forget what live I did it on, but I did it a week or so ago. Yeah, his phone searches. After the red drums, he's searching his phone for information, Googling for information on the red drums, and Googling his name and everything to see if they're connecting him and whatever. That's crazy. I'd also like to know what's in them phone calls. Who did he actually speak to just a couple hours after the red drums? But they were both calls that he made. I think all three. We only know how long two of them were. One was 34 minutes and the other one was 54 minutes. Like, what are you talking about at that time of the morning, starting at 6:17 a.m.? So 6:17 a.m., if that's Idaho time, it would be 8 something our time here on the East Coast. Oh. Yeah. The pollen this year is just no joke. Yeah, I can't wait for justice to be served too. Um Yeah, he also, after the red drums, up until he was arrested, he was saving videos. I wonder if he watched any of my reads and thought, oh shit, especially that one at the beginning of December that I did that described him to a T, but we didn't know who he was. I just described the perpetrator. I wonder if he's seen that video and went, oh shit, right? Because there was a bunch of the videos. It's like he was scouring for every bit of information he could get before he was arrested and saving them to his device. Everything about what happened at 112 King Road. So I wonder if he watched any of my videos. And if he did, he would have known then on December 9th that I described him to a T. Described how it was probably done as soon as that probable cause affidavit came out, and we knew what had happened before he was arrested, that the two upstairs, Kaylee and Maddie, and then Xana and Ethan, we knew all that stuff. Well, not all of the information, but we knew enough that somebody came in, got Kaylee and Maddie upstairs, and Xana and Ethan downstairs on the second floor. I called it in the order, where he parked, what direction he came in through that sliding door when everybody was saying, no, the front door was open. He came through the front door. No, he didn't. My reads told me he came through that back door. He parked in the back. He went upstairs first. And then on his way down, it came out in my read that he seen Xana. They were collateral damage. I said that right from the beginning before we even knew who Bryan Kohberger was. So it's really interesting what comes out later, right? Right, Carol? What if he did watch? Imagine if he watched that video, the first couple videos I did. It's like, oh my God, she is spot on. How does she know this? I don't. It's my ancestors that are on the other side that show me. Right? Marie says, I hope he did watch and panic. But that one arrest is coming. Even in that, I said the police have something that they're not telling us that's going to catch him. And that was the sheath. That only came out way, like February or March when they finally released the probable cause affidavit. We knew nothing about that. But I said, in that video, arrest coming, the police have something that they're not telling us. And that video that I did was on, I think, December 6th or December 9th. And that he also took something. So I can't wait for that to come out, because it also said that he took something from one of them. And then that song. Sorry, you guys, I got holes in my mouth. And then that song that he watched that he listened to, that he was listening to like an hour and a half to 2 hours before they busted through his doors. And apparently his parents were put in zip ties, his parents and his sister. But I also read that his sisters thought that he might have been involved in it. And they went to his dad, and his dad didn't want to hear nothing of it. So that's why I think the prosecution's going to call them. They're also going to call them to give evidence about, did you guys buy a K-bar and sheath on Amazon? Because apparently they were all on the same account. Did you guys buy it? Because he then, after the red drums, he went looking to replace that K-bar and sheath. Right? Aw, thank you, Rose. Thank you, Rose. K-Mitch says she thinks he took red stuff. No, I seen him pulling something off somebody's neck. Maybe a necklace or a bracelet or something. It's a piece of jewelry, I think. We'll see. We'll see what. Remember, I said that. He took something from one of the victims. And I was seeing something being ripped off someone's neck. And I do have the volume, you guys, all the way up This is if I want to turn it off, but no, I got it all the way up. So even if you're on a phone, even if you push your volume up for your ringer, click the three little dots that come up, because there's other volumes there for like your media, for notifications, for your ringer and all that. It's all there. You may have to crank up your volume on media. I have an area. I would, if it wasn't for so many planes falling out of the sky, I could maybe fly to Alberta or BC, rent a car, and then go into Idaho, because Idaho is right up near the top there, right up by the Canadian border. I could fly across Canada, rent a car, and drive into Idaho, because I have a feeling I know where he buried these things. Carol says I still had to turn up TV volume. Yeah, I find when I'm watching YouTube on my TV, I have to turn my TV way up, because on the TV, there's no volume button to turn up the actual volume on the video itself. So what you can do is go on your phone first, Carol, go to the video you want to watch and turn up the volume there. Leave it open while you open it on your TV, and I find sometimes that works. So then it's at the loudest volume on the video itself. I found that works sometimes. It's weird. I wish they would fix it. I wish they would put a volume button on the videos that are on, that you watch. If you watch it, I watch all mine on TV. Aw, where's mine, bro? Where's my avocado on toast? Oh, now you got me wanting avocado on toast. And I do have avocados in the fridge. So I don't know if this is going to be an all-day thing, you guys, but if it is going to be, when they take a lunch break, I'm going to have to make myself some lunch, because I'm 2 hours behind them. So if they take a break for lunch at 2, which would be noon their time, it'll be 4 o'clock here. So depending on how quick they go, I don't know. I don't know everything that they're going to touch on today, so yes, I love that too. Carol says I did that. Yeah, I would love to go down there and check it out, the area that I'm drawn to. Because believe me, there's only like, I think I broke it down. I think there's like a 17-minute delay before his phone. By the time, okay, let me do this. Court is on break. Let me bring up Google Earth. File open. Let's bring up Bryan Kohberger. Okay, let me get over here. And then I'll bring this up so you guys can see it. Okay, so let me stop. I've got it in the background, you guys, so I will hear it when it starts again, and I will automatically stop whatever I'm doing and go back to court as soon as I hear them. Okay, so here it is. Here. Okay, so I used Google Maps to see how long it would take to get from 1122 King Road all the way down to here where his phone comes back on. Okay, so this is right here. 4:48 a.m. his phone comes back on. I believe, if you want my honest opinion, Where's that spot? Let me find it. Right here. This area. I believe it's in here somewhere. I would love to search that. There's that area, and there was another one up here. Right here. Because I believe he just stopped on the side of the road and tossed it in, like, back into here. And I believe it's on this side, because this side, maybe these people would go through their bush here. But on this side, it's just farmers' fields. They just use machinery. They would never see a knife thrown in these bushes. Even once winter comes, a lot of these don't lead. There are a lot of like Christmas tree type trees in here. So I believe it's either in that stretch right here where he could have stopped without being seen, because there's all bushes here, without being seen, and tossed it in there. Either there or the other one. Where is it? Down here. In this area, maybe. And there's another one. Where did I see that? Oops, it's back up here. Here and here. There are two areas where he could, there's a lot of Christmas trees, like they don't have leaves. They're just all year round trees, where I think he could have thrown it in, just pulled off the side of the road, thrown it in and took off again. And there's nothing around there that would see him do that. Like if he pulled up here, even this place over here would not, it's just, there's a house over here, but they wouldn't see him because he'd be covered by these trees. That's how thick these like Christmas-like trees are here. So there's there, and there's here, where he could have stopped without being seen. Those are the two areas that I would like to search. Okay, so let me bring back up the court stream. There we go. And we're back. I know. I've got a craving for it, and I know they're going to come back soon, or I'd go and make it right now. I just showed you. I just showed you on video, Rose. Willow will lead me to the place, and I will dig, and we can do it ourselves. Yes, we could. And Rose would. Rose would come with me. Absolutely. We'd have to like rent a room in advance, like book it in advance and meet there. Because I know you're in Jersey, right? Unless I went and got you in Jersey, brought you here, and we could fly out from here. And then have to cross back into the States near Alberta or something, rent a car and cross back over into the States there. Or I could come and get you, and we could leave from Newark and fly into Idaho, rent a car in Idaho. Either way, we could do it. That would be a trip. You don't have a membership. You don't have a membership? I think you had gotten a free one at one time. Here, let me do that. Let me go over here. I think I got some memberships that I can still give out. Hang on a sec. I have to cut my sound, so give me a minute. Okay, who all got memberships? K. Mitch, Ear Sinner, Miss Horse Whispers, Mary on a Cross, and D. Lucky all got 30 days free membership. I tried to get you in there, Shy. It's the computer that I don't get to choose who gets them. It's YouTube's algorithm. I don't know what it'd cost. I mean, it'd be more expensive for me because our dollar's worth a lot less than yours. But yeah, I'm not keen on flying. That's why I said I'd fly across Canada. The flying in the States right now scares me. I know. I was hoping for you. I have my fingers crossed for you, Shy. Ear Sinner wins a lot. Yeah, I've never seen Ear Sinner comment though. And K Mitch, I think, has gotten a couple. Is K Mitch? Yes! uh, I tried. I tried, Jai. Let me bring up my studio here. What the hell? Oh, a street cleaner just went down our street. Aw. I can't wait to get it. I can't wait to get it. Like I said, it's supposed to be delivered on Saturday, so I'll be able to show it. I do live streams on Sundays to do reads for you guys. I do mini reads for you guys, or a question that you guys have that you want answered. And it doesn't have to be about the cases, it's about you guys, right? I do that every Sunday at 1 p.m. Eastern. So I'll be able to show your book then, and I will promote that for you for sure. Oh, sorry for the earpod wearers. I just whacked my mic. I went over to make sure my volume was turned back on, my speakers, I should say, so I could hear when Court came back. I am sorry for earpod users. We sure do. Aw, you're such a sweetheart. I wanted actually to fly out and see Marie this summer. I'd love to get back into Cali. But yeah, like I said, I just don't trust flying in the U.S. right now with all everything, all these planes that are going down, and that would be my luck. I would be on one of those planes, believe me. And then you guys would never get to see me again. Some would like that, and some of you wouldn't. Rose says, let's do it. Uh-oh. Carol, were you an earbud user? I'm sorry for anybody that just got that bang on the mic. Yeah, it'd be a cool trip. But yeah, I would fly across. I'd use Air Canada, and fly into, like, say, Alberta or something, and then rent a car and drive into Idaho. And then drive back to Alberta and jump on an Air Canada flight. Because from Alberta to here to Ottawa, I think it's like a 6 or 7 hour flight. 6 hour flight, 7 hours. You're very welcome, D Lucky. Free membership for a month. And we're going to have another giveaway for all members. So if you are a member, you will be put onto the wheel. That includes the ones that just got memberships today. and I will be doing a draw for the I Object. So one of you lucky members will win the I Object t-shirt for the summer when we cover the Bryan Kohberger trial. Yeah, like I would have to fly into BC and then drive all the way down the coast to get to California. That'd be a long drive. I wish I could just fly. If I could get an Air Canada flight from Ottawa to Cali without having to change like onto United Airlines or something, I would do it. I trust Air Canada. I know several of the mechanics from Air Canada that work on the Air Canada planes, but I don't think that's possible. I don't know. Yes, it is. It's crazy. I'd have to check and see. I know I am going to be taking off in June or July a week because I've got to go back to my hometown. I got to go back to Hamilton. There's people there I got to see. There's a good friend of mine that's really sick. Oh, a train would take 7 days to get out there, Carol. My husband loves, bring him with us. We need a man. We need a man there just to keep 9 for us. Keep 6. To watch our backs as we're searching. So yeah, if I was to do that, that's what I would do is I would fly into Alberta, rent a car, and then drive. It's convincing somebody here to come with me. Don says, flying to Saskatchewan. Saskatchewan would be too far away to have to drive from. That's one place I've never been. I was actually going to go. Don, you're going to remember this. There was actually a time when I was going to fly to Saskatchewan because a friend of mine, back in the day, you're going to remember this, Don. Back in the day, she was writing a book on Paul Bernardo and Carla Homolka. So she was going to go to Saskatchewan to interview Carla Homolka. And she wanted me to go with her just for the ride. Like, because she didn't want to go by herself. And Carla had agreed to meet with her. We had everything booked, and then she bowed out at the last minute. Because Carla was held in Saskatchewan for some time. Marie says, you could come. I could go from Ontario, Canada to Ontario, California. Dawn, you remember that? You remember that? Yeah, and we had everything booked. Everything booked. Our motel, everything, our flights, everything. We were mad. Okay, Shai, enjoy. This is a long half hour. Like, they've taken a long, long break. Let me just make sure. Hang on. Let me just refresh this and make sure they're not back. They are back. Hang on a sec.
But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware? I'm going to, while we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines. So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections. So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay. Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection. You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony, objection, overruled, sustained immediately, without even giving you much of a chance to express your concern greater, because I can usually anticipate what the potential issue is and whether or not it's an issue. That's it. If you think your ox has been gored and you need to address the issue more, either to have a record or in order to perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach and we will have that discussion. I'm sure by the end of the trial we'll have to replace the carpet from the trail leading from counsel to the bench, but that's fine. As I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking about. There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about that, whatever the issue may be. I have found in, doing this for far longer than I care to remember, that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is, as much as possible, to have those discussions here at the bench. Now, if it's a very significant issue that requires much more legroom, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff. One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it. That is not making a record, that is making a rebuttal. And at least until it goes over to State Street, I get the last word, and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with, is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared, so I can give you as best a ruling as I can, and so that you can make as best an argument as you can. If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available, so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper for it?
So let me know as far as advance as possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Thank you.
While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that?
Correct. No objections.
All right. Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
And I assume you have replacements you have or will get to me for those.
And actually, we had a procedural question we were going to ask the clerk, but I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not pick them
Okay.
up on this trip, but we will make arrangements to have that done certainly well before trial.
Very well.
Thank you, sir.
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that, to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, not by first name, while we're on the record. Again, avoid making accusations that you don't have the tickets for, or the receipts for, I should say. And under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be prepared, some flexibility about how witnesses are presented. You may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can accommodate that. And I ask you to both be accommodating to each other in that regard. All right, any questions about witnesses' testimony?
Just one, it's kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examinations so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to save bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome.
Yes, sir.
If we're having a law enforcement talk about a broad area of one phase of the investigation at a time, that's probably okay. But, having them come up and narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Your Honor, with that said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Yes, Your Honor.
And if you don't let them know that, and either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable. Because the remedy may be to strike all of their testimony as a starting point.
We would anticipate asking court and counsel if this witness may be excused if we're finished with them, and then that would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Okay. Likewise, when you look at each other's witness lists, talk with each other and then write it in, get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses, or whether they will essentially agree to make them available. Anything else with respect to witnesses before I move to exhibits?
No, sir.
Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where there's appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know, though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible, avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objections to authenticity. Some of the stuff, key actual evidence items, whether that's DNA or whatever it might be, obviously the defense is entitled to put the state to its burden with respect to chain of custody and all that, so I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you submitted those to the defense to review?
Yes.
And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Okay. And then I would certainly caution, at least because the state goes first for now, I'll say the state, that, belts and suspenders are good ideas when it comes to trial. So I would have my people I need to authenticate things under subpoena, just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight. So the methods of displaying evidence to the jury, generally there's 3 ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other 2 approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in writing. And hopefully that's what you're doing. There's an agreement in advance stipulation to admission of exhibits. I generally don't allow pre-admission because what I find is that I admit all these documents that then are never addressed during the course of the trial. And I don't want a bunch of exhibits to go back to the jury that they have no instructions on, that they've had no question and answer with a witness to explain what the relevance of those things are so that they can just go back and use to justify whatever position they want to have from them. And I think that's dangerous. And so the process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You're going to use Exhibit 6. Witness is on the stand, and just say, Your Honor, I'd like to go over Exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right, Exhibit 6 is admitted, and then we go from there. On voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant, right? So that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, Exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47, but they're separate exhibits so that the jury can keep those in mind, and we can keep track of those. It looks like from what I received, the state's using S- number for its exhibits, and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, it's like to say, the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay. I think my staff explained to you that in terms of submitting exhibits to the court in advance, If you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks. And try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here. Or if I need to take it home and read it overnight to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab with the sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever, and she'll hand it to you to use. At least for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury. And so that can go to the jury without fear of an accident happening. I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, will probably be in a display case. If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted, I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored. Whether that's with a sister agency or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain. Depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio, and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have an objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial. All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose. You can move about the well, but don't get in the juror's personal space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in that. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes or something like that when you have 30 minutes left, so just let me know in advance. All right, questions either about closings or about exhibits?
Your Honor, as to the defense exhibits, it would be helpful if they could be separated or at least delineated between which is for the penalty phase and the guilt phase, as the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
Your Honor, no problem. We did go over that when we met last week, and I identified which ones were for a phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay, well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if it's stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right, anything else before I move on to jury instructions?
Not from us, Your Honor, thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss. From the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and the presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense, and on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was the subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony. I don't have a problem with an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
Jury instructions, I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital instructions in the pre-proof phase that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together, so take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think that does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-proof, for example, any stipulations that they want me to advise the jury of, let me know by submitting a request and copying my law clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going to be. And, you know, for better or worse, as you know, the Supreme Court in last year, in 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. Certainly probably the next day, unless it's, you know, Friday morning when we get that, then we may not start till Monday or something. But given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can. If that happens and we are in a penalty phase and there is a finding of aggravating circumstances, where then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that, defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So, but I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do. I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that for purposes of post-conviction, we've documented that. Okay. Let the court reporter know whether you're going to want routinely daily transcripts or not. You don't have to tell her now, but
Daily versus real time?
so there's two options. You can have none, both, or all, or either. One is I think we can set up real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
There's separate fees if I want both.
Correct.
May I make that decision?
Yes, not now. You may make that as we get close. And just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Thank you.
And we obviously need to know, particularly about the real time in advance, so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at, with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior to
It'll be
phase
part of
two.
the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you can think of? All right. That's my list of stuff, and I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss, and so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors, so we'll do that in a closed session. But anything else in the public session we need to talk about?
I don't believe so, Your Honor. Thank you.
No, Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
Is there a spare that we could have, Your Honor?
Sure.
Oh, it's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side to preserve records, all right? All right. Anything else? All right, thank you. Why don't we come back in about an hour, all right?
All right.
Okay, that's it for today's hearing. They are going to now go to a closed hearing that they are going to discuss things that I guess we still can't know. But I think we got a lot in that one. I think Anne did a lot of tit for tat. You know what I mean? Being petty. I mean, I get it. She has to do what she has to do. Shai says not to be twisted, but I would pay to be a witness for that, right? I think a lot of people would. I mean, when something like this happens, it's scary, you know? But even if he is found guilty, you guys, and sentenced to the death penalty, there's going to be years and years and years and years and years before it actually gets to that point. I've seen people sit on death row for 20-something years because of the appeals, the appeal process. I know here in Canada, it goes through various different court systems, it could be 20, 25 years before, like, we don't have the death penalty here, but I've seen cases in the States where there's people, that have been on death row for over 20 years. So, I mean, if it comes to the point where he is finally, sentenced to the death penalty, I won't be around for it. You know what I mean? Like, I'm 61 years old now. I don't think I'm going to live to 80. Hopefully I do, but anything can happen. We never know when our day is up, right? Yeah, but he will sit on death row. So, but anyway, you guys, that is the hearing for today. I think we went over a lot of stuff before the hearing, and I don't know if the June 18th hearing is going to be able to be streamed. If it is, we will cover it. Oh, I didn't know. They didn't know. No, even the person firing, like the people that are firing the pew pews, they don't know themselves which one has the bullet. I was reading up about it, or I seen something about it that no, like I don't know how many of them there is. Say there's six. There's six guns all placed there. A bullet is put in one of them. Blanks are put in the others. And then the guns are mixed up, so nobody knows who it was that actually fired the bullet. But they're all sharpshooters, so they're whoever gets the gun with the bullet in, they're gonna know. Yes, good chatting with everybody too. So I'm gonna wrap it up, you guys. I got a few things that I got to get to this afternoon. Few things I got to get caught up on at home here that I've been putting off. So with that being said, I'm going to wrap it up. I want to thank each and every one of you for being here. Thank you for your super chat donations. If you gave one, thank you so much. Welcome to the new members. And members, be watching. If you're not a member of the channel yet, join memberships. In a week's time or so, I'm going to have a draw, and I'm going to be giving away one of the shirts that we are going to hopefully all be wearing during the BK trial. And it's our Juror 13 t-shirt. You can get it on my site. You can check the bonfire link down below each and every video. It's there. There's a link. Go check out my merch store there. I do have it there. You can get a hoodie, a sweatshirt, a shirt for any of my designs. Go check it out. So until the next time, you guys, don't forget on Sunday, live mini reads for you guys. You want your very own mini read? Come and see us 1 p.m. Sundays. I stick around as long as people are there to get reads. I'm going to be there. If it's a short day, I end early. So if you do want to read, make sure you get in there early. 1 p.m. Eastern is when I start, and we start doing the reads. So Kate Bell says, I'll be getting a shirt. But I will be giving one away. So wait, Kate Bell, for at least a week or so. Probably next week, I'm going to do that draw. And I will do it live right here. You know, I always do live draws. So you guys know there's no fandangling. So, and you have 24 hours to respond. If not, I will pull somebody else's name. I do that on my own. So there you go, you two. Thank you. Thank you all for being here. Good to see some familiar faces I haven't seen in a while. Good to see you guys all. I love you guys all so very much, and I appreciate each and every one of you. So with that being said, I'm going to end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. Like, that is important in today's society. Be aware of your surroundings. Okay. I love you guys to the moon and back. Bye-bye.